Hello, my name is Jason Lazarus, CEO of Synergy. Today, you'll hear from Rasa Fumagalli, Synergy's Director of MSP Compliance, and Evelyn Pacino, one of our MSP expert attorneys. They both have incredibly deep expertise and knowledge in all things Medicare secondary payer compliance. Also, like me, they are both attorneys and Medicare set-aside consultants certified. Through this video, you'll learn why MSP compliance is so incredibly important for plaintiff personal injury law firms.
Medicare secondary payer compliance is so important because it has such a significant impact on the injured party. If you don't comply with the Medicare Secondary Payer Act, which includes addressing conditional payments made under Part A and Part B, Advantage plans, which are Medicare Part C plans, your client may end up having their Social Security benefits garnished. You have to address conditional payments. You as a firm might also end up, being pursued by the Department of Treasury for double damages and so forth. You also have to talk to your client about the potential impact of Medicare denying post-settlement injury-related care when they present Medicare with additional bills for treatment after the case is settled. The way that Medicare would get all this information is through the Medicare mandatory insured reporting obligation, which is Section 111 reporting. That basically is the enforcement of the Medicare Secondary Payer Act, where the defense reports the settlement and the injury-related conditions to Medicare. You don't want to drop the ball on any of these three parts because the consequences for your client and your firm could be significant.
Yeah, there are a ton of risks to worry about. So one of the really big ones is that CMS can aggressively pursue both the client and the law firm if conditional payments are not addressed. And so for the attorney, that means that not only can Medicare go after the firm for the conditional payments, but also they can pursue double damages. So there's a lot of financial exposure there, as well as some harm to the firm's reputation, potentially. So a lot of risks there. And then for the client, ultimately, CMS will refer that debt over to the Department of Treasury. And so, that can mean that their Social Security benefits might be impacted, their Medicare benefits, their tax refund potentially could be impacted. So really important to get on top of that. Another risk to think about is that the client might end up actually paying more money to Medicare than they should. So, there's a dispute and appeals process that you can go through, but there are particular deadlines. There's processes to follow, so you have to be really careful about that. And then once the settlement is reported to CMS, the appeal options become more limited and interest begins to accrue if it's not addressed. So, again, some more financial exposure for the client there. And then lastly, the client might actually have trouble getting some of their claims paid for after the settlement. And so that's because CMS has the right to stop paying for injury-related care post-settlement. And so if your client is still treating, then they need to decide whether or not they're going to put some money aside, or if they have other coverage, if there's some other way that they're going to get those claims paid. And if not, they might not be able to get the care that they need. And even if they're not treating, they might still have some issues with Medicare down the road. So, Medicare makes mistakes and your client might need to fight back a little bit. And that's also something that we can help prepare them for. So there's a lot of risks that you got to worry about in this area.
I think the biggest thing to be concerned about is the fact that your firm could be hit up with double damages with the Department of Treasury action if you don't address conditional payments. Another one could be that your client can actually have their Social Security benefits garnished because of this conditional payment issue. Failure to talk to your client about post-settlement injury-related treatment is a pitfall. Bad settlement language is a pitfall as well. I think an important starting point is figure out who your clients are. Identify the Medicare beneficiaries that you are representing. You also have to understand Section 111 reporting. You have to figure out what the significance is. Make sure that settlement language is on point and not overbearing. Address conditional payments, have a process, educate your clients, monitor those liens.
There is a lot of confusion in this area, particularly because there is no law or regulation that actually requires setting up a Medicare set aside. But considering the risk that a client could have trouble getting their claims paid for post-settlement, I want to underscore just how important it is to pay attention to this issue and not to ignore it just because MSAs aren't mandated. So what the Medicare Secondary Payer Act requires is that Medicare's interests be protected post-settlement. And so the idea is that after the case ends, that any injury-related care should be paid from the recovery if that settlement funded future medicals. And so that's where CMS is getting their authority to deny claims post-settlement. Now, how they enforce it is through a different law, and it's through Section 111 of the Medicare, Medicaid, and SHIP Extension Act of 2007. And what that law does is it requires defense to report to CMS when a case ends, what the injury codes were, how much the settlement was. And so that's how CMS finds out about what was included and how they can flag claims going forward so that they might deny them post-settlement. And so that's really their main enforcement mechanism around whether you should do an MSA or not. And if a client does set up an MSA, CMS can monitor it by requesting an accounting. And so in work comp cases, they require that annually. In liability cases, there is no required reporting at this point. But if a person does spend their MSA down to zero, then CMS might require those records to make sure that the MSA was spent properly. And they might require that before they start paying for injury-related care again. So for that reason, it's really important that if a person does set up an MSA, that they follow those administration rules. So even though an MSA isn't required by law, there may still be consequences for not setting one up or for misusing it. And keep in mind, there's no one size fits all answer here. Every case is different, and ultimately it's going to be a risk assessment type of issue for the client for them to decide whether or not this makes sense for them. So that's why it's critical to analyze the case with an expert who can make recommendations specific to their unique situation.
I think the key is that law firms need to have a strategic approach to Medicare secondary payer compliance, and they also have to have an understanding of what MSP compliance involves. The place to start is to first off identify clients who are Medicare beneficiaries or who will have a reasonable expectation of Medicare entitlement within 30 months of settlement. When you are signing these clients up, pay attention to this. If a case is also lingering in your office for years, update this information to make sure that you don't overlook people who might have had a 65th birthday while the case was pending. Once you identify the Medicare beneficiaries, you should have a process in place to request conditional payment information from Medicare. You also need to identify whether there are Medicare Advantage plans, Part C or Part D plans at play. Once you have that information, you should carefully audit the conditional payment notices, the liens, to make sure that the treatment really is such where Medicare is a secondary payer, in fact. Another thing that firms should do is they should carefully review the settlement language. Oftentimes firms are, they're somewhat taken aback when they get 3 pages of MSP compliance addendums to their settlement terms. A lot of times you're going to have provisions that make absolutely no sense. They might request contingencies, for example, that Medicare review a liability a liability Medicare set aside. That is simply a condition that cannot be met. Another thing that we recommend is that start early. Do not wait to sort this out until you're at the mediation table or going to trial to find out that, whoa, my client is actually on Medicare and they're likely to require future injury-related treatment. If you start early, you can be ahead of the game. Another thing that you should be aware of is that it's really important to make sure that your clients are properly advised about the potential impact of Medicare on their ongoing eligibility for future injury-related care. The decision of what to do really depends upon your client's comfort level with risk and your firm's comfort level with risk. When you have this discussion with your client, or you consult with experts in that area that will consult and advise your client, it's key that you also document your file to show that the steps that you took at time of settlement, at time of disbursement, were taken in compliance with the Medicare Secondary Payer Act. When you follow all of these steps, you can ensure that your firm is compliant with the Medicare Secondary Payer Act.
When it comes to MSP compliance, partner with Synergy to protect your firm and your clients. Learn more today by contacting a Synergy expert.